Welcome to Bracewell's Environmental Essentials for In-House Counsel webinar series. This series is brought to you by Bracewell's Environment, Lands, and Resources Group. I'm Daniel Pope, and I'm here in Austin, Texas, and today we're going to be recapping the Texas Environmental Superconference that occurred earlier this month in Austin. The Superconference is put on by the Texas Environmental and Natural Resources Law section of the State Bar of Texas. And this year we had close to 500 attendees for the 2.5 days of panels, presentations, events, and receptions. And there was no shortage of topics. We had a wide variety, as we do every year, covering federal and state litigation updates, water issues and Texas coastal issues. We heard remarks from EPA Region 6 and TCEQ officials. We had a number of regulatory updates, federal and state and citizen enforcement topics. We heard about the state of climate policy. We heard updates on administrative law and more. We're not going to be able to cover all of these topics for a couple of reasons. The first is that we just simply can't spend about 30 seconds a piece on each presentation and panel. But more importantly, I thought that many of the best presentations and panels engaged with or touched on certain themes that ran throughout the entire Superconference. So rather than trying to discuss every particular panel, I want to trace some of those themes that emerged again and again. These themes really centered around projects and the public. How can citizens engage with projects and the permitting processes that are necessary for those projects? And then how is the public able to engage with those projects after agency action happens? We'll be diving into these topics today, and I hope that you find our discussion helpful, even if you attended the Environmental Law Superconference yourself. If there was a major character at this year's Superconference, it would have to be the data center, or more appropriately, the build-out of data center infrastructure all over the state of Texas, and of course, in other parts of the country as well. They were a subject of numerous panels, and an entire day. The Wednesday afternoon sessions were devoted to the data center build out, power and water needs associated with data centers, and the environmental issues that come with data center development and operations. A data center driven power demand has, of course, been in the headlines. And demand growth has increased from a sort of natural rate of growing generation every year of about 0.25% to a forecasted increases needed of 2 to 5% year over year. That's an increase in our rate of bringing on board new generation sources by about 8 to 20x. That's a really significant development that has had permutations and ramifications for a number of panels. And data center projects are having to figure out how to solve for their power and water needs in the state. And which one do you solve for is an important question. We heard lots of discussion about the generation needs and the water cooling needs for these data centers and the relationship between those two. You may be able to power your data center and get all of the water you need, and you could reduce your power consumption, but you would increase your water consumption by not treating it and reusing it. And if you were able to solve for your water needs, you would, of course, need more power to do so. We have hundreds of new significant infrastructure projects coming online in the state. Some of those have a 2 to a 5 year build time frame. We had some great presenters on these topics, including our partner, Jared Berg, who's in our Houston office, and our former colleague, Rachel Marsh, who's now with the Edison Electric Institute. They both presented on Wednesday and explored some of the challenges facing data center development, some of the opportunities, some of the needs for why we are seeing these projects come on board, and some of the lessons learned from developments in other parts of the country. We saw that the speed to power focus, and you've heard us talk about speed to power if you've attended our environmental law seminar. We talked about how that's only a part of the story, And we're seeing projects turn to a more holistic approach to data center development that involves addressing grid reliability concerns, resource usage, and the concerns about power affordability for residential customers near where these data centers are going in. Water infrastructure was also an important discussion in connection with the data center build-out. Texas is a growing state. It's growing in terms of its population and its industry. And water infrastructure is also needed to address topics like PFAS management. And data centers only add to those needs as developments come online. Further, some of these developments are happening in water-strained parts of the state west of I-35. Right before the Superconference kicked off, Governor Abbott issued a directive to Chairman Gleason and Chief Officer Vegas of the PUC and ERCOT, respectively, on the subject of data centers. That was also a big part of our discussion at the Superconference. Governor Abbott has directed data centers in the state to provide information to the Public Utility Commission and ERCOT regarding several issues. One, what are their power solutions? Are data center projects seeking to access ERCOT's grid? Or are they going to be developing their own power resources in a sort of behind-the-meter arrangement? What are their plans for water reuse? How are these data centers making use of grants, tax abatements, or other development incentives that they're seeking when they're siting their data centers? What strategies are these data centers using to reduce the impacts of noise, light, traffic, et cetera, on residential areas? And then finally, what are the true project sponsors? Who owns the project? Who's going to benefit from the project? If data center projects and their company sponsors are not responsive to these requests from the PUC and ERCOT at Governor Abbott's request, the governor has instructed that ERCOT interconnection requests are effectively paused for these projects. And if they don't respond at all, they'll be outright denied. The Data Center Coalition, one of the trade groups supporting and advocating for data center development in the state, has applauded the order. Why? Because this order will bring some clarity to the data center build-out, with real projects with serious backers being distinguished from more speculative endeavors. There are hundreds and hundreds of announced data center projects in the state, and it's been difficult for state government officials, the public, and even industry itself to identify just how many serious projects there are out there. But when we think about data centers and these projects, for those of us that have spent time with other industries and their permitting needs and challenges, we think we're going to see a lot of the same topics come up as citizens engage with these projects. So let's turn to developments in public participation. On July 7th, 2026, EPA issued a proposed rule regarding minor new source review air permitting public participation requirements. EPA proposed in July to remove certain public participation requirements for minor new source permits. EPA's SIP approval rules, as they currently are, require states to require public participation like notice and comment for both major and minor sources undergoing new source review permitting. EPA's proposal would remove the requirement that minor new sources undergo those same public participation requirements as required of major sources. But as many officials in the TCEQ were quick to point out, EPA's proposal might not necessarily change what public participation looks like in state air permitting processes. In EPA's proposal, it's not seeking to require that all states submit SIP revisions to remove minor source permitting public participation requirements. They're only making it possible, if states want to do so, to remove those public participation requirements from minor source permitting. So EPA's proposal, if it's finalized, wouldn't end up changing state regulations or state laws immediately. And in the case of Texas and many other states, state clean air acts often impose minor source permitting public participation requirements on their own. So if EPA finalizes the rule, nothing would immediately change for companies seeking minor new source review permits from the TCEQ. The Texas legislature, which will be convening next January, would need first to amend the Clean Air Act in Texas, and then TCEQ would be able to pursue these changes to minor new source review permitting. While we're talking about air, I just wanted to flag a couple of other things that came up a few times at the Superconference. On PM 2.5 standards, we're waiting to see what EPA is going to do following a court order to make attainment and non-attainment designations by February 2027. That's just a few months away from now, but that'll be 1 year after the statutory deadline, after EPA's statutory deadline to make those designations. Texas has taken the position that no counties should be designated as non-attainment for PM 2.5, and we'll see what EPA does with that position, whether it takes the same position or if it ends up designating a few of our counties in the state as non-attainment. We also heard from TCEQ Executive Director Kelly Keel that TCEQ is considering ways to relieve some of the pressure caused by the ozone standards, specifically by obtaining some Section 179B relief from non-attainment reclassification for counties that would have met the ozone standards, but for circumstances beyond their control, like the international transport of ozone. Shifting now to another set of topics that are related to public participation, insofar as, after a permit is issued or after an agency takes an action, then we look to see what federal enforcement policies are, or what citizen suit exposure might look like, or the role of contested cases, all of which were discussed at the Superconference and have some developments that are we're watching for. And we will, of course, after we provide you with this update, we'll continue to monitor and let you know when key decisions come down. On the subject of enforcement, EPA Assistant Administrator for the Office of Enforcement and Compliance Assurance, Jeff Hall, was in attendance. He spoke on EPA's enforcement posture, first by hearkening back to a December 5th, 2025 memo put out by OECA and under then Acting Assistant Administrator Craig Pritzloff, formerly of the Texas Commission on Environmental Quality. He reiterated that EPA under the Trump administration is focused on a compliance-first policy, and that reaches both to civil judicial enforcement matters and administrative enforcement, where the goal is seeking for regulated entities to come into compliance as quickly as possible, whether that is through enforcement mechanisms or otherwise. Assistant Administrator Jeff Hall also emphasized that EPA is going to be avoiding expanding regulatory burdens on regulated companies through what he called a deal-making mindset or a deal-making approach to enforcement. What he meant by that was, by deal-making mindset, Jeff Hall was referring to EPA's prior practice, in his view, that involved pursuing enforcement cases that weren't grounded firmly in the statute or in observed alleged violations as a way of obtaining concessions from regulated industry or enforcing individual companies to adopt monitoring requirements or other environmental compliance requirements that weren't thoroughly grounded in regulations applicable to those companies at their facilities. Administrator Hall also encouraged regulated companies to engage with EPA headquarters, saying that it's possible to engage with them if meritorious arguments about a particular enforcement matter are being routinely ignored by region enforcement officials. Most notably, and this leads into another big piece of news that we saw over the summer, Administrator Hall also talked about how the agency is re-examining its prior positions on citizen suits. And that leads into one of the big developments we saw from this summer in NAACP versus XAI. This is an ongoing federal citizen suit action in the United States District Court for the Northern District of Mississippi. The NAACP filed a citizen suit under the Clean Air Act against XAI and MZX Tech LLC concerning the data center build-out in the Memphis area and the power plants that have been built to support those data centers. The NAACP argues that MZX, which is building out the Colossus power plants, that MZX did not seek or obtain the air permits required for the construction and operation of these power plants. Over the summer, DOJ filed a motion to intervene in NAACP's citizen suit, and it's actually seeking outright dismissal of the lawsuit. What's DOJ's position? Well, first, it argues that the federal government and the state of Mississippi, which are the two enforcement authorities who oversee Clean Air Act permitting and compliance, oppose the citizen suit. Citizen suits are brought by citizens or non-governmental organizations only after providing notice to the federal government and the state, and then waiting for a period of time. Once that waiting period has ended, the citizens may actually commence a suit against those who are alleged to be violating a number of environmental statutes that includes the Clean Air Act, Clean Water Act, RCRA, the Endangered Species Act. DOJ takes the following positions in its motion for intervention and dismissal of the NAACP's citizen suit. First, DOJ argues that the federal government and Mississippi, the two enforcement authorities with oversight of Clean Air Act permitting and compliance, oppose the citizen suit. Well, why does that matter? Citizens, before they can commence a citizen suit, must provide notice to the federal government and the state where the violations are alleged to be occurring before they can sue in their own right. If the federal government or the state government commences enforcement, then the citizens cannot actually commence their own lawsuit against the alleged violator of the relevant laws and regulations. DOJ argues that this framework gives the federal government and Mississippi the ability to oppose and seek dismissal of the citizen suit. Citizen suits, according to DOJ, are fundamentally supplementary, or as the DOJ says, interstitial to federal and state enforcement actions. They fill a gap. They are not meant to be a primary kind of enforcement activity. And when the federal government and the states exercise their diligent prosecution, and when the federal government and the states, including the state of Mississippi, decide not to sue, there's an implied prohibition on citizen enforcement. That's implied by the diligent prosecution bar. Whenever the federal government or a state government are pursuing prosecution against an alleged violator, a citizen cannot bring its own lawsuit. The government argues that that provision impliedly prohibits citizens from pursuing a citizen suit when both the federal government and the state government have declined for policy reasons not to commence their own prosecutions. The DOJ also argues that if it is the case that the best reading of the Clean Air Act is that these kinds of suits are allowed even when the federal government and state government do not want to see them go forward, then we run into some serious constitutional questions. Congress certainly may have written citizen suit provisions into environmental statutes, but when it did so, it was invading the executive power of Article 2, that is to say, the executive branch, the president, and the Constitution vests the executive power solely in Article 2. On the state front, we're also watching, and there's a good bit of discussion about a case before the Texas Supreme Court. That case is San Antonio Bay Estuarine Waterkeeper versus TCEQ. And the Waterkeeper case emerges out of TCEQ's denial of Waterkeeper's contested case hearing request on an air permit application for a terminal facility in Point Comfort, Texas. Waterkeeper commented on the permit application for this air permit and sought a contested case hearing. TCEQ denied that contested case hearing and Waterkeeper challenged. After winning at the district court level and obtaining a remand to the TCEQ to review the contested case hearing request, TCEQ appealed the decision of the district court to the 15th Court of Appeals, which issued a very significant decision on how contested case hearing requests are reviewed and what project opponents must do before challenging the substance or before challenging TCEQ's action to issue the permit itself. The 15th Court of Appeals held that TCEQ decisions on contested case hearing requests are reviewed on the record with deference. In other words, when a court is reviewing TCEQ's denial of a contested case hearing request, it's not reviewing independently or de novo the claims that project opponents make about whether they are affected by a project. They're not hearing that for the first time. Instead, they're looking at whether TCEQ made a decision that is supported by the record. And that's a really deferential review. The courts are not to substitute their own judgment for the judgment of the agency. They're instead looking to the record to determine whether TCEQ could have made a reasonable decision. In fact, if TCEQ offers one rationale for the decision and the court finds that there's a better rationale, the decision will still be upheld. The 15th Court of Appeals also concluded in its opinion that project opponents must obtain a contested case hearing and participate in a contested case hearing if one's available for the particular application before they can challenge the TCEQ's action in issuing the permit. That's an exhaustion doctrine, and it's now before the Texas Supreme Court. And we're very curious to see what happens at oral argument in early November. Big question is, what counts as exhaustion? Is requesting a contested case hearing itself exhaustion, or is going through an entire contested case before the issuance of a permit what counts as exhaustion? These are up before the Texas Supreme Court, and there could be some pretty serious ramifications coming out of its decision, which it will issue in early 2027. I want to give a brief thank you for all of you who are still listening, who came to the Superconference and joined us for our Superconference reception Thursday evening. If you're listening to this and thinking about attending Superconference 2027, let me be the first to issue you an invitation to join us at our reception. We'd love to have you. It is a great time to visit with clients, consultants who work on projects right alongside us, and of course, many of our friends and the TCEQ and the Railroad Commission. I know that I personally enjoyed visiting with our friends who have worked with us on contested cases or who help us with audits. It's always fun to visit with you in person. I wanted to flag a couple of upcoming events that Bracewell will be putting on. First is our September 8th webinar. Shay Sahai is going to be talking about GHG reporting obligations and the state of those reporting obligations today. We also want to flag for you that we'll be holding our environmental law seminar in Houston, Texas on November the 10th. We'll be talking about produced water, source and project aggregation, and plenty of other topics. As always, we want to hear from you on topics of interest to you to cover in future webinars or at our environmental law seminar. Reach out to any of the Environment, Lands, and Resources members that you know. We hope to see you soon.